Thank you, everyone. Please be seated. And welcome to this special session of the Iowa Supreme Court held on the campus of Ankeny Centennial High School. We appreciate you taking time out of your evening to spend with us. We have one case that will be submitted this evening. That case is State of Iowa versus Troy Richard Brooks. Mr. Gangestad, you may proceed.
Thank you, Mr. Chief Justice, fellow members of the court, counsel. May it please the court. I believe that the summary in the program does an adequate job of kind of setting the stage in this case for our audience. So for purposes of the argument, I'm just going to kind of jump right into it tonight. A subject of much disagreement in this case centers on how to characterize the officers who came to the door of Mr. Brooks's bedroom. The state's position is that they were probation officers, but for all intents and purposes, they had the appearance of police. When this case was decided by the Court of Appeals...
Mr. Gangestad, they testified they were probation officers. They were employed by the 5th District Department. Isn't that correct?
They did testify that they were employed by the 5th Judicial District Department of Corrections. That's correct. And that they were classified as probation and parole officers.
Why isn't that the end of the issue?
Well, because they weren't. A normal probation officer is a supervisor of cases who supervise probationers. These guys did not supervise any cases at all. They were actually part of what was called the warrant team or fugitive team. Their entire duties was with that team and apprehending people who had absconded from custody.
Should that really make a difference? It seems at least plausible that you have a range of probation officers, some conducting just ordinary supervision, others playing the role of handling situations where there's danger involved, where a probation officer has to go encounter a person who might be dangerous under circumstances that indicate a problem. So shouldn't we say that that these particular probation officers were still part of the probation department and therefore within that classification?
While they were employed by the Department of Corrections and classified as probation officers, I believe that their primary purpose was law enforcement purpose, not a supervisory probation role.
But his regular case officer was tied up in court elsewhere, and shouldn't we give some deference to the district court's factual findings? She heard them testify firsthand and found that they were probation officers or serving in that role.
She did find that they were probation officers, certainly. And, of course, the district court is granted deference with regard to credibility issues. However, I believe that there was no reasonable person who could view these individuals and see that they were probation officers.
Are you conceding the fact that if they are probation officers, that the exclusionary rule doesn't apply?
No.
So what difference does it make if they're, under your argument, whether they're probation officers or police?
Well, if they were police officers, they'd be bound by the warrant requirement of the Article 1, Section 8 of the Iowa Constitution. The Supreme Court in State v. Short has recently stated that police officers, law enforcement officers, are required to get a warrant.
So are you conceding then that the special needs or community care doctrine is applicable here then?
No.
Then what difference does it make if they're police officers or parole officers or probation officers?
So I think first and foremost, obviously the warrant, we have a preference for the warrant in these kinds of situations. And we believe that a warrant should have been applied for in this case, a search warrant. If the court does not find that a warrant is required, it's basically our position that you have to get a warrant unless there's some reason you cannot get a warrant. Here, there was no showing by the state that it was.
Well, that's not exactly right. There's 31 or 32 exceptions to the warrant requirement under the federal Constitution. Now, we haven't examined the, scope and depth of those exceptions under the Iowa Constitution, and I don't know, where we're going to go there, and you're probably going to tell us where we should go.
Well, I believe that under the recent jurisprudence of this court, specifically in short, that the court stated we have little interest in allowing reasonableness clause to be a generalized trump card to override the warrant requirement in the context of home searches, and we reject the cases suggesting otherwise.
Well,
So-
what does the record show on the warrant? The facts suggest you had a emergent problem. It had to be handled quickly. An argument can be made that the warrant, getting a warrant, would have taken too long. What does the record show, and what's your argument on that point?
There was no record made by the state regarding how long it would have taken to obtain a warrant. In fact,
What kind of record did you make?
I asked the officers if they ever attempted to obtain a warrant, and the officer who actually was the probation officer, which was Mike Evans, he stated that he did not.
All right, so the record shows that there was no effort to obtain a warrant, but the record is silent as to whether it was practical or not to get a warrant?
I don't believe that there was any record specifically made on whether or not he was going to be able to obtain a warrant on that day. However, that would be the state's burden to prove that a warrant was not able to be obtained.
Now, the district court found there was an emergency. After all, you had the father and sister very concerned that he had locked himself in the room, had relapsed, was doing meth. Do you concede that there was an emergency situation?
No. Again, we believe that the warrant requirement here is the major problem with this situation.
Go ahead, finish now.
However, the community caretaking exception is in play here.
Let me change the facts a little. What if the father, instead of calling their probation officer, called the paramedics? And the paramedics broke into the room the same way these guys did by pounding on the door, and it opened. The knife got ajar that was jammed in the door jamb, to treat this guy rather than the probation officers or whatever they are. How would that change this situation?
So the community caretaking function or the community caretaking exception requires that the intrusion or the entry be totally divorced from the detection of crime.
And why doesn't this qualify?
Well,
It's totally divorced.
Well, in this case, these were law enforcement officers. They were
Well,
there
let's-
looking.
Okay, let's suppose we don't buy your argument there. Suppose we say, well, they worked for the probation people. Was this activity that they engaged in totally divorced? What's your argument that it was totally divorced?
We don't believe that it was. And to kind of back that up, what happened afterwards kind of shed some light on that. They immediately arrested Mr. Brooks. They searched the room, and then they immediately started asking him incriminating questions. To me, that seems much more like a law enforcement function than a supervisory parole
Well,
function.
what
What's the record
happens if
reflect
the
about
only-
the extent of the search? What does the record reflect? In the briefs, of course, everybody makes their own description of what they said. They just said they did a cursory review of the room, cursory search of the room, whatever you want to call it. It really wasn't an extensive search for evidence in the way that it's been perceived by me, but there was no search there that I could really tell.
He stated that after he had arrested Mr. Brooks and took him out of the room, Officer Wignall, I believe, stated that he conducted a kind of a cursory search of the room. He did not sound like he was too inclined to want to stay in the room for very long, but he did conduct a search. There was no evidence particularly found, any drugs or anything of that nature. However, the observations that they made of Mr. Brooks, the statements that Mr. Brooks made in response to questioning, certainly I believe would be fruit that would be excluded. Under
Well,
the
but some of that,
exclusionary rule.
let's parse that out. Some of that was before They entered the room. I mean, they got there, they had conversations with him through the door, I gather, right?
That's correct.
That comes in. The search hasn't happened yet, right?
Correct, but I don't think there's anything in the record that revealed there was any issues prior to him opening the door. In fact, I think there was the exact opposite. Mr. Brooks was answering questions through the door. He was alert. He was conscious. There wasn't any indication that he had overdosed or that there was anybody else in there that he was attempting to harm or anything of that nature.
Well, what about the comment, his own father is calling somebody in, saying, you need to do something. This guy is out of his head. He's using again. He's locked himself in his room, hasn't come out for 24 hours or however long a period the time was. And immediately upon the probation officers coming to the house, directs him up to the room to, do something. This guy, he's out of his head. He's using meth again.
I understand the the concerns of Mr. Brooks' father. Mr. Brooks' father did not testify at this hearing, so this information was coming through Officer Evans and Officer Wignall. So we don't really have a clear indication of what specifically
I think we do have his statements, though, when they were admitted at the hearing, right?
There were some statements that came in through the officer. There were some other alleged statements that were made on the report of violation that were not admitted at the hearing.
Let's change the facts a little. Let's say a son in a room, father pounds on the door, can't get the door open, has concern for the son's safety. Calls the paramedics, but they're tied up, and the police get there first, because paramedics usually go with police when there's situations like this. The police get there, the father says, I'm concerned, breaks the door down or gets in somehow, finds the son unconscious, but sees drugs and stuff in the room, administers to the kid, leaves the room, gets a warrant, and searches the room. I mean, would that be okay?
Are you talking the police actually broke the door down then?
Yeah, because there was someone in there non-responsive. I mean, would that be okay?
Well, if the police broke the door down and they were doing so in an attempt to perform an emergency function, then anything that they would see as a result of that entry.
Well, weren't these two gentlemen who came there trying to do an emergency function to see if this guy was okay based on the father's statements? I mean, what's the difference?
Again, I think that the record is pretty devoid of anything that would indicate that Mr. Brooks was experiencing an emergency.
2 days in a room with no food, not leaving for the bathroom, screaming and yelling. I mean, doesn't that seem like an emergency? I mean, if you had a kid doing that, what would you do?
I don't believe any of those facts were in the record in this case.
What is in the record, factually? What is in the record? You have two officers testifying, I believe, and that's the sum and substance of it. Wignall and Evans. What specific facts are in the record?
Again, it's the state's burden to prove
Well,
those
no,
facts.
that's not my question. It's the state's burden. I want to know what facts are in the record. And there's one particular fact I'm interested in, and that is that Wignall testified that the father had some concern for safety, did he not?
He did state that he had some concern for his safety, but it was devoid of any follow-up, I guess, or any substance to it. There was nobody that had stated they felt threatened by Mr. Brooks. Nobody stated that they'd been harmed by Mr. Brooks. There wasn't any evidence.
No, but he could be harming himself, and I mean it's not necessary he be harming someone else, right?
It's not necessary that he be harming someone else, but I don't think that there was any indication that he was in his room harming himself. He was conversing with the officers. He was talking to them.
Well, I don't know about conversing. I didn't see that in the record. I saw in the record that the probation officer testifying that he said he was going to open the door, but hadn't opened it yet. Now, I mean, to kind of sum it all up, is it sort of your position that if an 80-year-old man like Mr. Brooks's father calls and says, my son is relapsed on methamphetamine, he's locked himself in the room, he's been in there for a full day, he hasn't come out, he's out of his mind, that it's not, before responding to that situation, a peace officer of any kind has to go get a warrant? Is that essentially to sum up the position? Because I think those are the facts, right?
Well, I believe if the court is inclined to, in this case, to state that a warrant was not necessary, that this was a community caretaking activity, the officers in that situation are supposed to do only what's reasonably necessary to determine if there is an emergency situation. And in this case, it's the appellant's position that when they had that conversation with Mr. Brooks through the door, that they could see that he had not, again, he was breathing, he had not overdosed, he was conversing with the officer.
They hadn't seen him face to face. He was on the other side of the door, right?
That's correct.
They didn't know what and in fact, when they got through the door, he was, they said he was clearly under the influence, disoriented, covered in feces and so on. So doesn't that justify that they had some level of concern about him?
I'd see that amount of time.
You may answer.
I think they have to go on what they know at the time. And I think on what they knew at the time was we've got a father here who had some concerns. We checked on those concerns. We see that he's all right in there as far as we can tell. And we don't have any reason to break this door down and go in and get him at this time.
Counsel, before you sit down, I noted that the pre-sentence investigation report reveals that Brooks had a history of assaultive behavior before this particular incident, on top of the history with respect to methamphetamine addiction. Does the history of assaultive, does the record reveal whether the officers knew of the history of assaultive behavior?
The record does not reveal that. There is no record that Officer Evans had forwarded or gave that information to Officers Wignall or Smith.
Mr. Gangstad, I'm going to ask you one question before you sit down. In State versus King, a year or so ago, we held that a parole officer could enter and search the home of a parolee without a search warrant under the special needs exception to the warrant requirement. Why isn't this case just a 2.0 version of King, since we're dealing with a probationer here instead of a parolee?
Correct. I think in State versus King, the court took great pains to constrain the applicability of the doctrine, the special needs doctrine, and had a very, very narrowly tailored standard in that case. I counted 9 different things in the standard, or 9 different points in the standard that need to be met for that special needs standard to be applicable. And number 1, the person had to be on parole. Here we have a probationer. Again, may or may not make a difference if we're in the grand scheme of things, but we do have a search by a parole officer of a parolee. In this case, we've got a probationer and what we consider a law enforcement officer. The search in this case was also not consented to by Mr. Brooks. The state may make an argument that there was consent there. I don't believe that the record reveals anything that would show that Mr. Brooks consented to that search. Again, must be done to promote the goals of parole or probation and divorce from the general goals of law enforcement.
Well, there's a requirement of ongoing supervisory relations. And that wasn't present here, I gather, with respect to the warrant team that showed up, right?
Correct. I think that that relationship between probation officer, parole officer, and supervisee is important. When somebody came and knocked on Mr. Brooks's door and stated, hey, this is the warrant team or the fugitive team, I wouldn't feel comfortable opening up that door at that time. I wouldn't feel that that was my probation officer.
Well, the whole purpose of special needs under the United States cases, Griffin, emphasizes a special relationship between the probation or parole, depending on context, and the individual. It's not like a law enforcement. It's not like a law enforcement relationship that is potentially adversarial.
I don't mean to keep this, I'll go ahead and answer his question, but I do have a question for you after you're done.
I'm sorry, Justice Apple, I didn't.
Why don't you just move on to the next question?
You said that he identified himself, I thought, as law enforcement. I thought the record indicated, Mr. Wignall said, we announced ourselves as probation and parole. Is that what the record states?
Mr. Brooks stated that when they knocked on the door, he heard them say the warrant team when Mr. Brooks testified at the hearing.
Was there contrary testimony at the hearing?
There was. I believe that Officer Wignall stated that they were probation parole. But he did identify himself as with the fugitive team or the warrant team as well during the hearing.
Thank you, counsel. You can follow up on rebuttal.
Thank you, Your Honor.
Ms. Triick.
May it please the court. Counsel. When courts grant suspended sentences and release defendants struggling with drug addiction on probation, those supervising those probationers need to be able to bring defendants back into custody if they relapse and become a public safety concern. And the supervisory authority must be able to send individuals equipped by their training and experience to deal with this sort of dangerous.
Can I interrupt you for a second? What is the state's position on the application of the exclusionary rule if there is no exception to the warrant requirement?
So the Kane holds that the exclusionary rule.
Right, old case. There was a lot of water over the dam since that one. I mean, does Klein take Kane out of the mix, or does the warrant, I understand the argument, and maybe it's your best argument, either exigent circumstances or special needs, if we adopt those under the Iowa Constitution. I think we have exigent circumstances. I don't know we've talked about special needs, but my concern is, and I'd like to know the state's position.
So I think that the state's position is slightly nuanced here, so I want to make sure that I'm clear. The state's position is that in this case, this court does not need to decide the larger constitutional question of whether the exclusionary rule generally applies in probation and parole proceedings such that Kane should or shouldn't be overruled because there was no constitutional violation here. That is not to say that it isn't, because it's also the state's position that at the district court level, the state is entitled to rely on the established, stable precedent of this court that the exclusionary rule does not apply in probation and parole revocation proceedings and can reasonably rely on that precedent going forward until or unless it is overruled by this court.
Well, maybe we need to address that so the state has a clear understanding of what the law or law isn't in the future if we do bypass that issue and go to special needs or go to exigent circumstances.
I do agree that there's certainly a draw to that sort of reasoning, but I think this court has a well-established constitutional avoidance doctrine that says we do not decide larger constitutional questions if they're not necessary to resolve this case.
It bothers me that the state's position is we're going to continue to not get warrants, go in, and the exclusionary rule doesn't apply, and rely on that. That, if that's the state's position, you alarm me that maybe it needs to be reached.
Well, the exclusionary rule does not apply in probation and parole revocation hearings, just as a plethora of constitutional rights do not apply in such proceedings. It's certainly not the state's position that probationer and parolees do not have constitutional rights or that those rights don't apply in criminal prosecutions. But probation and parole revocation proceedings are not criminal prosecutions. We're not determining guilt or innocence. We consider things like whether an individual's silence can be used against them. We don't have to prove violations by beyond a reasonable doubt. So it's not as if the state is suggesting that in all contexts these constitutional rights do not apply.
If we hold that a warrant is required under this situation, do we run the risk that in future cases there will be a delay attributed to getting a warrant and somebody on the other side of that door may fatally overdose?
Certainly. I think there's two dangers.
Yeah, that's an argument for repealing the warrant requirement altogether, isn't it? Because there's always a delay, and get a short delay.
Well, certainly, although I think we have exceptions to deal with that in situations.
We do,
such as
including special needs.
special needs or the community caretaking exception.
Right. Let's deal with special needs first. I would
Well,
like to go.
could I get an answer to my question before you move on to Justice Apples, please?
Certainly, I think that there's both dangers, and certainly there could have definitely been dangers in this situation had we delayed. We really do not know what happened, and I think that there was credible testimony that Mr. Brooks was a danger to himself or others. There's also dangers to the operation of the entire system. We're going to impose significant costs on the probation and parole system by requiring warrants to be gotten, not just because we require to get the warrants, but then we're going to have to litigate these issues in probation and parole revocation proceedings, and particularly in parole.
Sounds like you don't want a warrant requirement, and you don't want courts.
Well, probation and parole has been
I
working.
mean, that's more efficient, and then you wouldn't have any of these problems.
What we don't want to do is criminalize the probation and parole system. The probation and parole system is a system that's been working well for quite a long time now, and it's set up on the idea that we're going to rehabilitate individuals that otherwise would end up in our prisons.
All right, let's get into the actual law here, and let's deal with special needs first.
Okay.
And it seems to me clear that whether or not special needs potentially kicks in under our case law does turn on the question of whether this warrant team would be characterized as law enforcement or probation. If it's a law enforcement function, I think it's quite clear under our case law that your special needs argument would fail. On the other hand, I think it's clear under our case law as well that if the officers are characterized as probation officers, then you may succeed. So I want to focus on that issue. It is true, in fact, all the facts are pretty much undisputed. It is absolutely true that the paymaster was probation, no dispute. But the argument the other side runs something like this. They were trained as police. They were certified police officers, went through the law enforcement academy. They appeared like police. They wore patches on their sleeves that said Polk County Sheriff. They had guns, ammunition, handcuffs, etc. They had responsibilities like police. They arrested and transported people. They did not supervise probationers, as I understand the record. They did not do home visits. And they acted like police. They announced their presence. They gained entry. They immediately handcuffed. So if they're trained like police, appear like police, have responsibilities like police, and act like police, aren't they police?
So I would contest the second two of those things. I
police.
can see that they were trained as police. They're certified law enforcement officers. Now, that doesn't make them general law enforcement officers. They're certified peace officers. And they did wear shirts that say police, but I think it's sort of the definition of form over substance to say the fact that their
really?
shirt.
And they have guns, they have handcuffs, they have police, and they have Polk County Sheriff insignia?
Certainly.
And that's just... why do they have that, by the way, as probationers who are working with clients and trying to assist their rehabilitation?
Why do they have shirts that say police, or why do they have guns and handcuffs?
Shirts that say police and Polk County Sheriff and so forth?
I don't think the record reveals the answer to that question. I think that it's important to understand why we make this distinction, and it's not a distinction between police officers. It's a distinction between general law enforcement officers and probation officers, and we make this.
Don't we want to look at the function of what they're doing? To me, there's nothing, whether they look like law enforcement officers or police or anything else, but what is the law enforcement function that they're carrying out by going into this person's room?
They're not serving a law enforcement function. They're serving a probationary function, and that is the important distinction here. Probation and parole has situations where it would be totally unreasonable for us to send untrained sort of social worker-esque probation and parole officers in. And instead of calling general law enforcement officers who have their own intents, who have their own purposes, probation and parole has hired people who are, by their training and experience, able to handle these situations.
What's in the record on that? Doesn't the record show that the one with the ongoing supervisory relationship with this person was in trial and was unable to handle it and so called in it? I mean, what does the record actually show?
The record shows that the supervising probation officer was indisposed in court with another case. The record shows that when he got out of court, he checked in and all the relevant action had been completed in this case.
Okay, so he was in court, and he couldn't be two places at once. That's what
Correct.
the record shows.
Correct.
As a certified law enforcement officer, he had arrest powers outside the probation area. He had transport powers outside the probation area. It seems to me that this arrangement was because Polk County has a large probation department, they could hire in-house police. Whereas if you go to some of the smaller counties in the rural areas, they can't hire in-house police. So in this situation, the probation officer would have called the local police department. And so just because Polk County has a little more money than the other ones, does that mean that they're not police?
I think that that question begs the question whether this situation is worse or better. I think that it does make a distinction that these officers, these certified peace officers, do not serve a general law enforcement function. They do not have a job that involves that. They do not have supervisors.
But under the code, they can. And under the code, they can be asked to do that. And in fact, they were asked to do that here because the guy wasn't available, where normally they'd call a police officer to go in, where they don't have these in-house police.
Well, placing someone under arrest for a probation or parole violation, the state would certainly suggest is a probation or parole function and not a function of general law enforcement. And the fact that, I think if you look at the broader facts of this case, But
a probation officer doesn't have the authority to put someone under arrest because where's he going to take him, to his office and tell him to sit in the corner? No, you have to call the police to take him down to the local jail. And here they took him to Polk County Jail. I mean, and that's the fallacy, I think, you have to get me over that hump because they were acting as police because they arrested him and took him to jail. And in any other county where they don't have these in-house police officers, it would have been done that way.
Ms. Triick, let me ask the question this way, if I could. Mr. Evans was the probation officer that was assigned to Mr. Brooks, the defendant here.
correct.
And he was tied up in court in Lucas County, and so he called in this fugitive squad or the arrest squad. But did the probation officer, Mr. Evans, ever testify what he would have done had he been available to respond to the call?
No, he did not. And I think that
Well, what are we supposed to make of what happened here then?
of the lack of specificity in the evidence. So I think that this brings me all the way back to Kane. And something that this court said in its argument last week, I believe that it was discussed that whenever we overrule existing precedent, that we undermine the predictability and the stability of our law in this state. And in this case, the state reasonably relied on our law in this state being predictable and stable.
Well, what do you make of Klein, which overruled a number of cases and used a completely different analysis from Kane? Kane focused solely on deterrence, function of the exclusionary rule, and Klein said, no, we no longer focus solely on deterrence, but we include the substantive constitutional right, and we include the integrity of the court system in not admitting unlawful evidence. And indeed, in Klein, we adopted the view of the minority of the United States Supreme Court cases that Kane embraced. So it's a little late in the day to say we should follow Kane when its engineering was certainly undermined in Klein.
To any extent that Klein does undermine the reasoning in Kane, I'm not certain it does. Klein mentions Kane without suggesting it's going to be overruled, but I would point this court to King, which is an even more recent decision of this Supreme Court. And when we're asking whether or not a decision should be overruled, we have to ask if its reasoning is clearly erroneous. And the reasoning in Kane remains consistent with this court's reasoning in King. Both recognized the continued legitimacy of a reasoning that suggests that the purposes of probation and parole are dual. They're rehabilitation and public safety, and that it's difficult or perhaps even impossible to achieve these goals without intrusion on privacy. The court in King said that the supervision of parolees requires intervention at the first sign of trouble and at the earliest stage of suspicion. Research has suggested that intrusive supervision does reduce recidivism.
Right, but in King, had it been a police officer, the search would have been invalid, right?
I mean,
Sure,
perhaps
I'm
it
sure.
would. Perhaps it would. But that doesn't undermine the fact that Kane and King both rely upon this same presumption.
Can I, do you mind, I know your time is elapsing, and I do want to get into community caretaking a little bit, which is, I think, please correct me if I'm wrong, but it's kind of an alternate ground for a search without the warrant requirement. And I've noticed that the United States Supreme Court has really 3 cases that have dealt with this community caretaking exception, all involving automobiles. I got kind of interested in that, and I kind of pursued it through, and it turns out there are at least 4 federal circuits that limit the community caretaking solely to automobiles, and they have a exegesis as to why that's so. Automobiles are mobile, et cetera, and then they cite language in Katie and other cases saying that it's limited. Then there's other cases, 8th Circuit is one, and 6th Circuit I think is another, say no, the community caretaking is not limited, that it's broader. And I take it you're arguing that it's broader because I don't see an automobile involved here. Now, why is it that this community caretaking doctrine should be expanded beyond the context, at least, that the United States Supreme Court has applied it, and that is automobile situations where there's the potential of fleeting evidence and fleeting issues?
Well, I'm not aware of the United States Supreme Court saying that it only applies to automobiles.
Oh, it didn't say only applied, but it emphasized. I mean, Katie has language saying, among other things, that this was an automobile, and when you're dealing with automobiles, you have the risk of movement and so forth. But I agree with you, it doesn't say only. These 4 circuits say only as an interpretation of what the Supreme Court did.
So I think the test for community caretaking has been well established, and I think that the answer to that question really just lies in the application of that test, and does the test, as applied to these facts, allow for the application of the community caretaking exception in this context, and whether or not the public need or interest in allowing the officer to engage in that bona fide community caretaking function outweighs the intrusion on the privacy of the citizen. I think that the exclusionary rule in the criminal context, excluding in the criminal context and not excluding in the probationary context, is a reasonable recognition of this court's justification that probationers may be searched for probationary purposes and not for law enforcement purposes, and Kane should be upheld. So the state respectfully requests this court uphold the revocation of Mr. Brooks' probation. Thank you.
Thank you, Ms. Triick. Mr. Gangestad, you may present your rebuttal argument.
With regard to the state's position on the exclusionary rule and its application to this case, it's the appellant's position that there is disagreement between Klein and King. And in Kane, there were 2 justifications that they upheld the not using of the exclusionary rule in probation violations. One was that our Constitution traditionally tracked with that of the 4th Amendment, and under Ochoa, we don't do that anymore. The second justification was totally taken from State versus Swartz. And in State versus Swartz, that was a exclusionary rule case with regard to sentencing. It's important to note that Swartz never once mentions Article 1, Section 8, or analyzes it independent of any federal constitutional provisions. It only
Well, that's right, but in Kane, we kind of adopted Schwartz, and under the Iowa Constitution, did we not? I mean, it's a little brief paragraph, but it says we adopt the Schwartz analysis, and we'd see no need to revisit it.
Sure. However, there were only federal cases that it actually looked at, and it's also stated that the purpose is to deter police misconduct, which is exactly the rule or exactly the justification that was specifically disavowed of in Klein. In Klein, the court stated that the purpose of the exclusionary rule is to remedy constitutional violations and put somebody back in the position that they would have been in prior to the violation even occurring. So there's a greater purpose behind our exclusionary rule under our constitutional provision.
What about the community caretaking? That your opponent suggests that it shouldn't be limited to automobiles, for example, that some of the circuits do, that in fact it should be much broader, and that it turns not on location, but the nature, I'm putting words in her mouth, but kind of the nature of the underlying facts, and what's your view on that question?
Well, I'm not aware of any situations where the exception has been applied to cases in Iowa other than in situations involving vehicles.
Well, that's correct, but I also think it's correct that there's no language in any of the cases that I could see, please tell me if I'm wrong, but I didn't see language saying it never applies outside. It just happened that the cases were automobile cases. But the argument would be, well, that's not a significant constitutional fact, that it ought to apply to places that are concrete, like a house. What's your view on that?
Well, our Constitution protects people, and I think in this case, with the formulation that the court has with regard to the community caretaking function, it focuses on, number one, is there a seizure? So in that vein, I guess you're going to have a lot more cases with vehicles where there's a seizure involved. But there's also, the fact whether or not there's a community caretaker function involved, and number three, the public interest has to outweigh the expectation of privacy of the person themselves. And in a home, I can think of no other place that a person could be than in their home, in their bedroom, that is more sacred, more more protected than a person's bedroom. So for the state to assert that this was a de minimis intrusion, I really take issue with that.
Does the father, as owner of the house, have any right to allow the emergency responders to enter the bedroom within that house he owns?
So the record did establish that Mr. Brooks paid rent to his father, and he had the right to exclude his father from his room. Therefore, he has, if there are two...
Well, I just want to make sure that I'm clear. The record establishes that only by the testimony of your client, who says, well, I was paying rent, but then in other parts of the record it says that he was being allowed to live there by his father. So we really have inconsistent information regarding whether he was actually paying rent, and we have no other evidence other than his bare statement that I'm paying rent. Isn't that correct?
Well,
that's the status of the record?
I think that that the record has more concrete evidence that he was paying his father for rent.
What is that?
Mr. Brooks' statement.
Other than his statement, what other evidence is in the record?
Well, his belongings were in the room. Mr. Brooks' father told him that was his son's room. Again, like I said, Mr. Brooks stated that he could tell his father that he was not allowed to be in his room. He had put a knife in the door to exclude the rest of his family from the room. And I believe there's case law stating that he also, as the tenant of that room, or the person who occupies that room, if he objects, a co-tenant or co-owner of the house cannot then give consent to enter.
And that typically goes with somebody who's actually paying rent, a non-relative, doesn't it? Usually applies in that situation, not to a family member that's living and has his own bedroom, or just like any of our children may have our own bedroom in our room. Does that mean they have special protections?
I think that a co-tenant can exclude a person with their objection can overcome a consent of a otherwise protected area.
Thank you, Chief. I just want to follow up on this issue of why these probation officers that had guns and responded to high-risk situations were there. Am I correct that the regular probation officer testified, and I think I'm quoting from him, I also contacted my co-workers, Wignall and Smith, who were on the fugitive unit as well, and asked that they respond to the address because I was indisposed at another hearing at the time. Is that the record?
The record is that at the time that this occurred, Mr. Evans was what I would call a normal supervisory probation officer. he had transitioned to be on the warrant team very shortly after this incident occurred. So when he talks about his coworkers or his colleagues, he's referring to them as his colleagues on the warrant team because they're all now on the warrant team together.
So if I read the record, I'll find the rest of that.
I think I'm trying to fill in the spaces for you.
But those folks went because Evans asked them to because he was not available. He was in Lucas County, right?
So my understanding is that he actually spoke to his supervisor, and he told them to contact the warrant team.
All right. And I think that's right too. But he contacted those people to go because he couldn't go, right? That's what he said.
Right. He was unavailable to be there.
Thank you, Counsel.
Thank you.
The case of State versus Brooks is now then submitted to the court. And before asking the bailiff to adjourn court, let me just direct a few comments to those that are in attendance. We hold court outside of Des Moines and communities across Iowa to give more Iowans an opportunity to see our state Supreme Court do its work, and to also help enhance understanding of the role of courts and its important role in governing. We hope that this has been an interesting experience for you, and it has been helpful in allowing you to see a different side of the court that you would otherwise not be exposed to. We have been to 22 communities across the state since 2011, and we have been to 145 high schools in conjunction with visits like this. I think what you have witnessed is the complexity of the cases that we are presented with. They are far from one-dimensional, but involve many, many interests for us to all consider. And as you can see, they involve very important matters for many, many people and in all communities. We will now write a written opinion that will fully explain the conclusion that we reach and the reasons for it. It will take perhaps 90 days, but if you're interested in following along, you can go on our website. It's iowacourts.gov, and we file opinions that can be read on that website. And finally, let me just say that Thomas Jefferson wrote about 125 years ago that of the importance of the public to be informed about the way government operates. And I think he would be very, very proud to see such a great crowd here tonight to watch this special session of court. We will welcome the opportunity to talk with you and to greet you at the reception that follows immediately right outside this auditorium. Thank you so much again for being with us. With that, I would ask the bailiff to adjourn court.